Heather, and this is episode 56 of the Canton Cover-Up, Commonwealth versus Karen Reed, and also Aiden Turtleboy Carney. It is pronounced Carney, not Kearney, if anybody was wondering. So we are here today to talk about Aiden going back to court. So last Thursday, he had a court hearing for his witness intimidation charges. Apparently, in Massachusetts, you can't intimidate witnesses or even emotionally harm them in some form or fashion, because that's what the statute says. It's very broad, it's really unconstitutional the way that it's written, and it is being weaponized right now against a blogger. They always love to throw in the word that he's a blogger, but really he's an activist, he's a journalist. He does a lot of investigative reporting and he digs deep into cases, and that's why they don't like him because he outs them, the witnesses, as suspects in this case, and they've been trying to silence him ever since. So, we're going to go through his court proceedings that happened on Thursday and kind of see how the Commonwealth has been giving him the runaround for over a year now, I think. Yeah, over a year now, or about a year now. So we are going to watch that. But first, I have a clip for you and a little information about when a jury reaches a verdict. Well, according to the Massachusetts whatever website, I can't remember what this came off of, but this is an official Massachusetts court document, and these are the this is the normal suggested language to read to a jury, the jury instructions about what to do regarding reaching a verdict. This was not read. These words were not read by Judge Canoni. So I'm going to read this, and then we're going to watch a clip of where she actually kind of addresses it, but never says anything that comes close to this. So this is what judges should be reading to their jury. Reaching a verdict. For each charge, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of that specific charge. You may not find the defendant guilty on any charge just because you think the defendant did something else that was wrong or improper. Your decision as to each charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip for each charge. When all 12 jurors agree on the verdict for a particular charge, the foreperson should check off that verdict and then sign and date the slip in ink. Let me read that sentence one more time. When all 12 jurors agree on the verdict for a particular charge, the foreperson should check off that verdict and then sign and date the slip in ink. For each charge, if you all agree that the Commonwealth has proved every element of the charge beyond a reasonable doubt, then you should find that defendant is guilty of that charge. On the other hand, if you all agree that the Commonwealth did not prove one or more elements of a particular charge beyond a reasonable doubt, then your verdict must be not guilty on that charge. That is what she should have read. We are going to actually watch what she says. She never says any of this language. And in fact, she even says parts like that are so confusing and contradicting, where she might say on the one hand, like whatever I'm saying right now is going to be given to you in handwriting, and then you'll have a copy of this all in the jury room. But then she says later on, if my words differ from what's on this paper, then you must remember my word, or you must take my words as what is true. It's like, what? It's written here, but I'm supposed to remember your words. That's supposed to be the accurate. No. So, anyways, that was her, or that's what she should have read. Let's read, or let's watch what she actually did. Hold on. There we go. Uh, Here.
Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions.
Tell any. Okay. Sorry. I'll play it through the whole way. But don't tell anyone, including me, how anyone stands. So let's start that over.
Tell anyone, including me, how the jury stands numerically or otherwise on the questions before such time as you have reached a unanimous verdict. You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict slips and notify the court officer that you have reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts to the court.
Let's read or go back just a moment. Listen to what she says again.
Member of the jury is in complete agreement with the verdict. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge.
After the final vote of the jury, sorry, the foreperson should check the appropriate boxes. So the way she's making it seem is like it's all or nothing almost. She has not differentiated that you need to come up with a verdict for each of the charges. For one charge, each page has one separate charge. Come up with a verdict for each of those. She didn't say that. She didn't distinguish it like that. So let's look at the words one more time. Sorry, here we go. All right, so your decision as to each charge must be unanimous, meaning that all 12 deliberating juries must agree. You will receive one verdict slip. She didn't say any of this. One verdict slip for each charge. When all 12 jurors agree on the verdict for a particular charge, the foreperson should check off that verdict. That's not what she says. She says, remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict. She's not differentiating them like with a particular verdict before moving on. Anyways, so after the final vote of the jury, the foreperson should check the appropriate boxes as to each charge. Is that what she's saying? The appropriate that's supposed to be it's purposely confusing. And I believe this is Bev's language. I don't think that I know that the attorneys have input when it comes to the jury instructions, but the judge has the final say as to what language comes in and what doesn't. So she could have very well been responsible for this very confusing language, which I think was done on purpose just to confuse. So, yeah, what do you guys think about that? Let me know in the comments if you think Bev purposely gave confusing language. Sorry, my hair is sitting on it. I'm gonna fix it. Anyways, so let me know in the comments if you think that she purposely changed the language to be confusing or whatnot. Is this something that you think she uses all the time, the same language? Let me know, because they also took off the not guilty boxes on the verdict slips. So it's really hard to think that it's not on purpose. I mean, I have a hard time thinking that Judge Bev is not in on it. All right, so the next topic that I want to talk about is okay, so last week we had four jurors come forward, at least two came forward directly to Karen Reed's attorneys, and two came forward through intermediaries. And they all said that, according to the affidavits, that unanimously they had um, all voted not guilty for counts one and counts three. So count one is second degree homicide, which requires intention and malice, and charge number two, which they were hung on, was the manslaughter charges, driving, and all the lesser charges. So driving under the influence and all that stuff, which was very confusing. And then the third charge was leaving the scene. And that again has to do with like intentionality and knowing that you did it. So I think a lot of people think that she did it on accident, which I don't understand how if you were paying attention in the trial. Maybe Lolly with his lollygagging confused you because he was very slow, and I think he purposely threw in just as many witnesses as he could to confuse the jury. And I think it worked, or they had a plan. I don't know. Anyway, so the fifth juror has come forward, not in a court document officially yet, but according to Aiden Carney's tweets as of July 12th, he says, breaking, I can confirm that the foreman is not one of the four jurors who has reportedly said that the count on homicide was 12 and 0. So he's the fifth juror. He is the fifth and the first to be on the record as saying he believed Karen Reed is guilty of manslaughter. So that makes his stating that they were unanimous on the homicide charge, that makes it even more credible, I think, if he thought she was guilty of manslaughter. Because um, otherwise, yeah, what he could have just said, no, we were guilty. So, but he's telling the truth, or, allegedly telling the truth, hopefully. All right, so then he continues on and saying, I can now report with confidence that the foreman of the Karen Reed jury is a former police officer and a current physician's assistant for surgeons in the Boston hospital, was one of the guilty voters for manslaughter. Colleagues of his have reached out and said that he was stuck on, quote, pieces of taillight embedded in John O'Keefe's shirt, end quote. That's not even true. That was not a fact that came out in trial. That was Lolly trying to confuse everyone. And he had been saying, Lolly had been stating in prior pre-trial hearings that these taillight pieces were embedded in his clothing, like microscopic taillight pieces. Come on. We don't even know the whatchamacallit, the chain of custody for John's clothing. We know they were on the floor in the hospital. We know that there's some shady stuff going on with the taillight pieces themselves. So why do we believe that, buddy? You're a former cop. Why are you stuck on that? That's dumb. But okay. You're entitled to your opinion. All right, so this medical professional apparently ignored the lack of bruising or other injuries below the neck and ignored the testimony of two ARCA experts who said that John's injuries were inconsistent with a vehicle collision. In other words, planting microscopic taillight fragments in a search a year later successfully kept the jury hung on count two. So, Michael Proctor, you won, I guess, but not really because you're going down. All right, so it is notable that the foreman is telling the same story. Homicide 2 was off the table. The jury was only hung on manslaughter. None of them believed that Karen Reed intentionally hit him with her car and left him there to lose his life in the cold. Aiden Kearney goes on to say, I do have his name, and although there is nothing illegal about posting it, I don't believe that doing so adds much to the story, so I'm not going to. I have reached out to him directly for comment, but have not heard back. So he's confirmed that it's the gentleman. Somehow he's confirmed his sources, but because they work with him, I guess, but the gentleman does not want to talk so far. But that's what we have on the fifth juror. And hopefully this week, hopefully today, as I'm recording this, maybe more will come out about juror 5, and maybe we'll get some more affidavits from juror 6 through 12, hopefully. And maybe even some of the alternates as to their experiences to being kicked off or whatever. I don't know. The people that got kicked off. All right, so we're gonna go to now the hearing for Aiden. And yeah, there we go.
Robert Cosgrove. Matters on for discovery motions if the parties could please.
So Robert Cosgrove, I can slow this down a little bit if it's too fast. Robert Cosgrove is the attorney that has stepped in for Ken Mello, who is the special prosecutor assigned to this case. Ken Mello has been having health issues or something. I don't know. I think he really just wants off the case. So this Cosgrove guy is stepping in. This is the second hearing, I believe, that he's attended as to Aiden Carney's charges. So he is still getting himself caught up or whatever, but they're still not turning over things. So let's listen.
Please state their appearances for the record.
Good afternoon, Your Honor. Robert Cosgrove, Special Assistant Attorney for the Commonwealth.
Hey, D.A. Cosgrove, good afternoon.
Hello, Your Honor. Timothy Bradle on behalf of Aiden Carney. Before the court is my client, Aiden Carney.
Attorney Bradle, Mr. Carney, good afternoon.
Apologies, it's just audio.
And Your Honor, one of the motions that I believe is on for today is the Rule 17 motion.
Correct.
I don't know if anybody from Verizon is here. I did give them notice as ordered by the court, but I am.
The Rule 17, I'm not exactly sure what that is, but I know they're trying to get, it has something to do with them getting text messages between LG, I don't even want to say her name, Lindsay Gattani is her name. That's the ex-mistress that Turtleboy was with, and she is the reason why he spent 60 days in jail because she made up some bogus um, like DV charges on him, assault and battery charges. And it didn't happen. It wasn't true. She was colluding with Brian Tully, the Brian Tully the that is the boss of Buchanan and others in the force or in the Massachusetts State Police. So Tully is a lieutenant, and Tully and Ken Mello, the attorney, the special prosecutor, were both in communication with Lindsay the night that Aiden went over there and the incident supposedly happened. She's the one that went crazy on him, first of all. Second of all, he left and she was mad about that. Um, so she did not want him to leave. She was yelling at him in that video. He did a video. It's just audio again where she's yelling at him. It's on his channel if you're curious. Um, she's the unhinged one. Like, do people not understand that the people on the Commonwealth side are completely unhinged? It's really insane the things that they are willing to do to make it look like the Karen Reed side is bad. That's all they want is to make free Karen Reed people look bad, especially Aiden Carney. And it's a huge smear campaign, and it has been from the beginning, I think, with Jen McCabe behind the helm of it all. She's the one working the PR, I guarantee.
Aware that the owner of the cell phone has retained an attorney.
Oh, so anyways, Lindsay Gattani, that's who they're talking about, the cell phone extraction. Brian Tully handed something over, but he did hand over transcript or cell phone records or whatever it was, but it was like highly filtered. It was very, selected is the term. Like, he didn't provide all of it. It was only like selected texts or whatever that he handed over. So they're trying to get it all. They're trying to get the actual data extraction from her phone because they know she was colluding with a DA, or not a DA, but a prosecutor and a state trooper lieutenant.
And she is here to address the court. I don't know if she wants to introduce herself at this time.
Morning, Your Honor. Sorry, Tanya Gravel on behalf of Ms. Catani.
Good afternoon, Ms. Graham.
And Your Honor, before we begin getting into the motions before the court today, could Mr. Bradel and I be heard briefly at sidebar?
So Lindsay's there. She has representation. Cosgrove represents the Commonwealth, and Timothy Bradel is the attorney for Aidan Carney.
Of course.
Thank you.
All right. Nobody's talking here. Hold on. Sorry. 1 second.
So if I may, Your Honor.
Please.
It seems to me, I don't know what new issues we might take up today, but it seems to me the last time there were 4 or 5 things that we discussed that the court was looking for responses on. One was the Rule 14 discovery motion. The second, the court directed me to file a response to the motion for special discovery. Third was the Rule 17 motion that I've already alluded to. Fourth was the motion to disqualify special counsel, which was put over to today. I don't know if we're going forward on that today or not. And finally, the court inquired.
They want to disqualify Attorney Mello. There's a motion to disqualify the prosecutor, and Mello hasn't been attending court ever since that was filed. So how can he have a hearing on it if he doesn't go to these hearings?
About the status of the motion for a bill of particulars. I informed the court at that time that I understood that Mr. Mello was working on it. And my understanding is that they've since filed a bill of particulars. I might imagine that Mr. Bradel has some comments to make about that. But, I guess we'll find out.
Bill of particulars is like a list of what he did that was illegal. So they wrote out a long criminal complaint, and they quoted him out of context many, many times within the complaint, but nothing he did was illegal. So they're trying to say, or they're trying to find out, like, what did he do that was so illegal? Why do you have him? Why do you have charges on him? He attended a rolling rally. So did 75 other people. Why aren't they charged? We've seen footage now of, after this trial, reporters going up to the Proctor home and asking questions. Are they going to be charged for witness intimidation, or is that just Turtleboy? Like, why are they asking, or why are they doing this to him? What is illegal about it? Let's set a precedent, or not set a precedent, but like, let's set some ground rules here so we know where the line is, instead of let's just have a broad statute that we can use to weaponize people whenever we want, because that seems to be what they're doing.
So that pretty much covers, I think, what's
And in terms
from last time.
I know that you had filed, I'm sorry to interrupt you, but I know that you had filed notices of the discovery that has been provided up to this point. There were copies of letters that were provided to Attorney Bradel. What's your sense, ADA Cosgrove, of where discovery stands at this point on both cases?
Well, I think we're probably at the point, I would say, where 98% of the discovery has been provided. There are a few things that I want to do further investigation of. I expect that most of those can be cleared up fairly quickly. I will say that when I walked into court for the first time on this case for hearing before Your Honor, I thought the discovery was almost completed then, and Mr. Bradel surprised me with a fairly lengthy list of things that he was missing that I have since done my best to respond to. To what extent to his satisfaction, I don't know. So we'll see what we'll see what today brings, but I think most of the Rule 14 discovery should probably be provided fairly presently. And then I'll file a comprehensive list and a certification that I have done so. I don't want to certify that I've provided all the discovery until I'm confident that I have.
Understandable. And I know that you did file a response to the request for special request for discovery, that there were certain areas that you had outlined where there were objections to that, to certain requests, and also indicated whether they had been, they were in the custody and control of the Commonwealth at this point as well, too. So I'll hear.
Yes, and I hope I understood correctly that what Your Honor asked me to do was to respond to the motion, not that you had allowed the motion, and that I was to provide it, although Your Honor is obviously prepared by reading the materials. You can see that from the letter that I provided Mr. Bradel, that some of the discovery he asked for that the Commonwealth agreed to, I included right in the letter.
Okay, thank you. Attorney Bradel, what's your position on where discovery stands now?
Judge, I have a different view of it. There's a lot of really important things that are not provided. The first area that I want to talk about, Judge, is my client's phones and computers that were taken out of his home a very long time ago. We have nothing in terms of the contents that was taken from my client. And that's a huge problem. And
His computer, his phones, everything that he used, his sources that were on those things, all of his reporting, and they won't give it back.
there's a lot of reasons why my client needs those items back. He's a professional journalist. They took all of his work product from his entire career. And in there are confidential sources. There's personal communications. There's medical things. There's investigative things on the very same state police officers that are charging him here. So they have a self-interest and a conflict in getting into his devices. And they've kept these things for months and months and months.
Those were seized pursuant to a search warrant?
Yes, Your Honor. And we've never seen hide or hair of any of it. And now that brings me to my second point, which is that the government is bound by the strictures of preventive medicine here. It's the case that requires when the government seizes items that implicate an attorney-client privilege, and we would contend other privileges as well, such as the attorney, as the journalist privilege, husband-wife disqualification. There's all sorts of privileges that would be implicated by the fact that they took all of his electronic devices. And but at a bare minimum, preventive medicine talks about attorney-client privilege items. And Mr. Carney has been involved in litigation as of the time of the seizure, unrelated to this. Civil things, restraining orders, other cases where he's the victim, all kinds of attorney-client communications are filled in his electronic devices. And we haven't been given a copy of that. And at the same time, the government is supposed to comply with preventive medicine, which they haven't. And I'll get to that in a second. But nothing in their duty to comply with preventive medicine stops them from giving us back. Either give us back the items, because we know they took a mirror image of everything, give him back his physical items, number one. And if they don't want to do that, if they want to trip him up somehow and not give him the items back, they needed to give us the discovery by May 8th, Your Honor's first deadline, by June 13th, Your Honor's second deadline. How about by today? We still don't have anything in terms of my client's phones. And they could have given us.
Let me just stop you there for a minute. 88 Cosgrove, is that within the 2% of the discovery that's still outstanding?
No, actually, Your Honor, Mr. Bradel brings up a point that I was intending to address with you a little later this afternoon, but since we've come to it now, let me address it now. There are actually 5 search warrants involved in this case. 2 of them involving a different party, and 3 of them involving the defendant. One was for his home, one was for things like cell phone, portable devices, and one was for his vehicle. And I just have a little, read you a little excerpt, one paragraph from a 32-page affidavit that will give you flavor, I think, of what was alleged in the warrant. I have it.
while you're looking for that, is there a reason why the items that were seized have not been copied and provided as part of discovery?
Yes, and I will explain that. Apparently don't have it, my apologies. Shortly after the items were seized, and this predates my involvement on the case, so I don't know if Attorney Bradel wishes to comment on this point. My understanding was that Attorney Bradel was in touch with Attorney Mello and said, can't go ahead and search these because we need a taint team procedure under preventative medicine. Attorney Mello agreed to that and set up.
So they needed an intermediary team who has no skin in the game to look through these things, and they're not on the prosecution side, they're not on the, they just have to do um, an unbiased look.
About finding some personnel for the taint team, which he identified. I was actually originally brought onto this case, Your Honor, to provide advice on legal issues, among them putting together a motion to set up a taint team. Before I could get oriented and underway on that, Attorney Mello experienced some personal illness, so I have been pressed into other matters of which Your Honor is quite familiar, and that has taken me away from putting together a motion for a taint team, although I have completed a draft out for several people to look at, and I hope to file it shortly. But as Your Honor knows, the normal process with the taint team is that a forensic investigator, an assistant district attorney or assistant attorney general in the office who are not involved in working on the case or the investigation in any way is assigned to do a preliminary screen, filter out possible attorney-client privilege materials, and then the specially assigned assistant DA, who is on the taint team, looks at those materials, makes an initial determination of whether they contain attorney-client privilege material, and then provides that list to the court, along with a copy of the seized items to the defendant, or at least to the person whose electronic devices are being examined. In this case, it's the same person. That person and his attorney then have an opportunity to examine the list with the aid of copies of their own devices, and come back and make an argument to the court as to other things that should be excluded that they claim the so-called taint team has missed. The court makes a ruling on that. Then once that's taken care of, the results are turned over to the prosecuting team and search commences of the materials that are not deemed to contain the attorney-client privilege. I think we are almost ready to proceed on that. In this case, because of the district attorney's desire to separate this from another ongoing case and to have special prosecutor assigned to the case, we don't have the option of using another ADA in the office or another forensic examiner who works for the DA's office for the taint team. That would more or less defeat the purpose of the special prosecutor. So we have identified outside people to do this. I did happen to speak just yesterday to the person identified that we intend to identify as the forensic examiner to make sure that he was still on board, since it's been a while, as Mr. Bradel correctly points out, and I'm advised that he is. So I would expect that hopefully by the next time I'm
Sorry, the thing cut out, so I had to get a second stream. Here we go.
That's what I mean, Judge. The council tried to comply. It just wasn't the right thing, I think, that they sent. Or we couldn't open it. I forget the exact issue with it or whatever it was, but we didn't get it. And so I'm just asking for that it be sent. It was either another date
I'll
or
make another
something.
copy, or get another copy. I'm
It
sure.
was not that document.
Okay. Any other outstanding discovery issues?
There are items, Judge, that we can't open, that don't have the right driver, that can only be used on a computer that has like 1998 Windows. You know, we went through all this. Council suggested maybe some of this is user error. We have the most experienced computer people. They figured it all out. The Celebrate stuff was given to us with some reader from like years ago, doesn't work, and we're working on that. There were some other video items that we can't open, and I'll just keep trying to work with the Commonwealth on that.
It's not a
They're handing over a bunch of evidence that can't be opened without programs, like without having the actual program to look at it. Like, why don't you just send a JPEG like normal people or a PDF? They're sending these odd files.
unusual that exactly. It's not unusual that happens with the number of players and proprietary software that's out there. So I encourage you to continue to work together on that.
I will just say that the readers provided, the readers that we used to open those documents, and I'm not aware that we have other readers, but Mr. Bradel has indicated a willingness to continue working on this, and I'm sure we'll do our best to meet him halfway.
Well, you know, I appreciate that, Judge, but the best was supposed to be done May 8th. The best was supposed to be done June 13th. And here we are again. You know, I'd like a little more than just we'll do our best. I mean, could the court?
Yeah, exactly. Do something about this, court. Stop pushing the ball along, or whatever the term is. Stop just pushing it along, throwing it, down the road, because this is a continual problem with the Commonwealth, that they're not turning over the discovery that the defense is asking for. It exists, or it did at one time, but it doesn't now, which is the problem. Why are you keeping the information? I can't defend myself when I don't have all the information, like all the text messages to Tully from the victim, supposed victim. LG, who has she has a restraining order against Turtleboy. So if she shows up somewhere and he's there, he's got to leave, which is such BS. And they're trying to throw that out too. He had a court appearance on that, and they just kicked the can down the road. That's the term. Kick the can down the road one more time. And that's what they're going to do here again. But at least he does some things. And we'll get to that. But anyway, so here is Bradel continuing to argue about discovery that they don't have.
Could I ask the court to impose a date certain, as we lawyers like to say, so that I can know when this is going to come?
I don't think it's my responsibility to buy software for Mr. Bradel. We provided him with the software that we use for the documents, and he's having trouble with it. We'll assist if we can, but I don't think our obligation extends to being a computer technician.
It's not your obligation to hand over some kind of file that other people can read. Yeah, I think it is. You can't just use that as an excuse, like, well, they can't read it, so what? They don't have the right software. Oh, well. No, you're supposed to hand over evidence and data that can be useful to the other side, or can be at least viewable, accessible to the other side. And they're hiding whatever they're hiding behind this discovery BS. They're playing such games, and it irritates me so much. Like, I'm infuriated for Turtleboy, because do you know how much money it costs for lawyers and to defend yourself, and then for attorneys and judges to just kick the can down the road? It's like, no, I want to resolve this. It's stressful. It's a horrible thing I have to stress about, deal with, blah, blah, blah. Let's finish this. Let's put an end to this, because Turtleboy doesn't even deserve to be in the courtroom right now. I mean, it's so stupid that he's there. And by the way, I realized that my background should have said Norfolk Superior Court, and that is where we're at. I fixed that. So
It does extend to providing us discovery, and if the means they provide it with, Judge, does not work, they need to find another means.
Okay. Continue to work together on that issue.
Thank you.
Thanks, Judge.
Are we ready to move on to the Rule 17?
Rule 17, Your Honor, yes. Judge, if I may, I would file this one under a no-brainer that this is a Rule 17 situation. First of all, the notion that the government can oppose a third-party request, I would submit inherently violates my client's due process. What does the government, what business is it of theirs to defend or to fight off a request to a third party for non-privileged records, Your Honor? And I would.
So the Commonwealth, who doesn't represent Lindsay, is trying to object to them getting these records, which really is telling, because if they didn't have anything shady going on, if Brian Tully and Ken Mello weren't involved, those two names weren't in on the conversation with Lindsay, then if they weren't, then just hand it over. Why are we having so much trouble? If your guys didn't do anything wrong, let us have her phone records from that night. But no, they don't want to do that because they know Tully and Mello were talking to her and they're trying to hide it. So, but the point is, why is the Commonwealth? Well, that's the reason why, but exactly Tim Bradle's point, the Commonwealth shouldn't be stepping in and intercede, being the middle ground for Lindsay Catani and protecting her. What are you protecting her for? The state should be totally unbiased, but they're not.
Point by analogy to the civil side of the docket. As the court sees all the time on the civil end of things, a civil lawyer can file a record keeper deposition to a record keeper at Verizon and have it notarized and send it off and get any sort of non-privileged records they want without taking all this judicial time. And so here we are where my client's very liberty is at stake. We have the government trying to trip us up, trying to argue that it's not relevant, trying to argue that we shouldn't have something from a third party, and interposing all of these factual arguments that I read in counsel's submission about he said, she said, Ms. Catani said this happened, Mr. Carney said that happened, blah, blah, blah. What we have is Exhibit B to my submission, Your Honor, that Detective Tully wrote in his report, and I have it highlighted here, it's the first full paragraph on the second page. Mr. Mello, and again, this makes Mello a witness, and it makes the Verizon records absolutely germane and important to my client. Ms. Catani at 10:30 at night calls the special prosecutor, Mr. Mello. They have a conversation.
Why is Lindsay Catani calling the prosecutor in Aiden's case?
She says to him that Mr. Carney's at her apartment. Mr. Mello then forwards the call to Detective Tully. Detective Tully's listening in on what's going on in the house, says he can't quite understand anything being said because the voice is.
And they have Turtleboy on some kind of wiretapping, yet they're listening in illegally on conversations between Turtleboy and Lindsay Catani that night when she tried to get him into her apartment and he didn't want to go, but she kept trying to get him in the apartment because he was staying out like in the lobby area. And he's like, I don't want to, she like begged him to come see her. So she came and under false pretenses, and then showed him like all the stuff she had on the other side. He made a bunch of notes. Then she wouldn't give him his notes and basically said, you can't leave because whatever. She was having like an insane breakdown, psychopath, whatever. So after that, then the next day, she reports that she was pushed onto the couch by Turtleboy. He shoved her onto the couch. That was assault and battery, according to her. And now she has a restraining order against him, which is so ridiculous. This is just another reason why not to trust the Commonwealth, not to trust the investigation into John O'Keefe's loss of life, because similar players, Lieutenant Tully, Brian Tully, and Ken Mello's new, like he was assigned especially to Aiden Carney's trial, but there's still some similar players. Proctor, Michael Proctor, what's his face? I don't know. They're all the same. So these state troopers that all back the blue, back the brotherhood. Anyways,
Are muffled. He's trying to listen in.
so that's what they're talking about. Brian Tully and Ken Mello are trying to listen in on Lindsay Catani and Aiden's conversation that night before they charged him with A and B for shoving her on a couch.
Unbeknownst to Mr. Carney. After several minutes, he's listening for several minutes. And then at 10:48 p.m., Lindsay sent me the following text message. Ken said to call you, but I can't now. Ken, I mean, whether he's not there on a first name basis here, Ken said to call me.
Ken Mello.
To call you, but I can't now. He's knocking on the bathroom door. I have to go back out. Please don't call or text, and tell Ken not to, because he wants to see my phone. I'm deleting our calls and texts right now. Don't respond until you hear from me, please. So it's
Lindsay is telling Brian or texting that to them or messaging that to them.
memorialized in a state police report that she, Tully, and Mello are all talking together and are all privy to Ms. Catani destroying evidence. And there's nothing in the police report that you might expect to see where Detective Tully might say, whoa, don't destroy evidence, just leave it, figure out something else. There's no mention of anything when she says to him that she's going to destroy evidence to not do it. So the evidence is gone. And we know that, Judge, from the discovery that we have been given, that there are messages missing. And that's what I mean when I say this is a complete no-brainer, that we need to go to Verizon to see if we can get messages, records to show that there were text messages there, that there were phone records that are gone from the actual device.
Do you have it downloaded for a device?
Yes, we do, Your Honor.
And
there are missing sections, absolutely. And it corroborates it corroborates.
The data that was turned over is missing sections, and that's what they're saying. We want all of it.
The detective's report. You know, he wrote it, that she said this, that she's deleting things.
And doesn't that provide you with an ability to cross-examine that witness about deleting things and removing particular items?
I'm not worried about the cross-examination, but I want to see what was said.
Yeah.
You know, what if that will determine, is Mello and Tully putting words in her mouth? Are they saying what to do? Are they, we contend, and I should rewind a little bit, Judge, we contend that this whole visit was a setup of Mr. Carney.
Mm-hmm.
And they delivered a summons to Ms. Catani that day after a very contentious court hearing on Friday, as I recall. They delivered a summons to Ms. Catani for no particular reason that I can see. She wasn't a witness in anything. They delivered a summons to her. She got right on the phone to texting Mr. Carney, and we have all these text messages that telling Mr. Carney that she got summoned, and the upshot of it is that she says we should do it in person, and the last text message is, I have it right here. Ms. Catani says to him, the last line, but I think we should save anything else for in person. And my client said agreed, in person. And she has him come to her house. So this whole thing was to lure Mr. Carney over there. And it was his first taste of freedom. And then they revoke his bail for this incident. And we contend the whole thing was a setup. And that is borne out by the fact that these two were on the phone with her at 10:30 at night. And evidence is deleted. And
what are they doing talking to her in the first place? They shouldn't have been talking to her at all. I don't know why she was calling Brian Tully personally. And Ken Mello personally, calling him Ken. They're on a first name basis. Disgusting.
we need to go beyond Ms. Catani, Mr. Tully, Mr. Mello to the carrier to see what, if anything, is there, if anything is still preserved.
But you're not going to get content. You would get records showing that there was either text communication, a length of the message, correct, or phone calls.
No, these carriers are all over the place. Some of them give you content, some of them don't. Some of them will show that there was something there that was dismissed, or deleted rather. They're all over the place. But in terms of a discovery request, these are non-privileged third-party records. And I just wonder, why is the government scratching and screaming that we can't have this stuff. It makes me wonder even more, what is in there? And it's incredibly important. It's germane to the case. It's an admitted destruction of evidence. So we can't just rely on them or cross-examine that they destroyed evidence. We still have a chance to see what the evidence is.
And how do you go from that particular date to the expansive request that you've made?
Well, I think it justifies an examination into the relationship here, the ongoing relationship between the district attorney, the special assistant district attorney, who she called Ken, and Ms. Catani, and how much communication was there, and to what extent is he a witness, and to what extent is he participating in what we contend is a plan to lure Mr. Carney to the house and then get him in trouble and revoke his bail, which is exactly what happened. And this specious assault and battery charge that was the alleged violence that Mr. Carney was supposedly wreaking on Ms. Catani was abandoned by the government. They didn't even indict it. They indicted the other two charges, but they didn't even indict the assault and battery charge. So all this is evidence that there was a setup here, and that the prosecutor was involved on the phone with them at 10:30 at night. So, and it's memorialized in their reports that evidence was destroyed, deleted, and taken off the phone. So I don't think we need to go any further than that, Judge, in terms of all the Lampron requirements. It's just a discovery request for non-privileged items. So I would ask you to allow it.
Thank you.
Thank you.
Commonwealth?
Well, I will resist the temptation to make light of counsel's comment that his motion is a no-brainer. I agree, but probably not for the reasons that...
This guy sounds so annoying. He drones on and on. He could give Adam Lally a run for his money and being boring and droning on and on and on.
he set forth. I do give him points for novelty. It might be nice if the Supreme Judicial Court had not set forth a Lampron procedure in criminal cases, but it has. And traditionally, the Commonwealth is entitled to be heard on Rule 17 motions, and we are being heard. So I'm not quite sure that it's a Rule 17 motion that we are hearing, because what I hear Mr. Bradel say is in terms of discovery request, and the case law is quite clear that a Rule 17 motion is not a discovery motion. It's a motion to acquire evidence after a very specific set of showings set forth in Lampron and successive cases, that the evidence exists, that it's material, that it's relevant, that it's admissible, and with some I never can say that word, I'm sorry, specificity as to what it's going to produce, not, well, this looks suspicious, so let's see what we can find out. It's not a discovery motion. I listened to Mr. Bradel, and it seems to me he omitted the elephant in the room, which is, as I alluded to in my response to his motion, when he looked at Ms. Catani's phone, and or maybe perhaps independent of that, I'm not sure. In any case, he asked for text messages between Lieutenant Tully and Ms. Catani. I spoke to Lieutenant Tully about it. He said, yes, I can bring those up on my phone and print them out for you. So I said, would you do that, please? I'd like to take a look at them and reach my own opinion as to whether or not they are discoverable. He did that. I said, yes, they're discoverable. And I turned them over to Mr. Bradel. So all of the deleted text messages between himself, between Lieutenant Tully and Ms. Catani, they've been provided in discovery. The relevant time period, you can slice it how your Honor wants, but I would indicate there's probably about 10 texts back and forth, beginning at 6:27 p.m. on December 23rd, when she calls and asks for a phone number. There's some conversation about that. Eventually she gets to one of the few, I think, substantive things as to what happened on that night, which is this. Ken said to call you. This is Saturday, December 23rd at 10:48 p.m. Ken said to call you, but I can't now. He's knocking on the bathroom door. I have to go back out. Please don't text or call, and tell Ken not to, because he wants to see my phone. I'm deleting our calls and texts right now. Please don't respond until you hear from me, please.
She sent that to Brian Tully. So Tully knew she was deleting evidence, and they were secretly listening in on this conversation, or on her conversations with him, trying to, anyways. Um, that's probably illegal wiretapping. I'm sure there was a few other illegal things that the cops just did there, and the prosecutor. So why is that not being looked at? Hmm?
And that's pretty much it. The following day, on December 25th, which is also pertinent, she indicates that to Lieutenant Tully that she just got a call from a Holden police sergeant who told her that the defendant told them that he would be coming to the station to turn him in when he didn't do it. And that's about it in terms of the communications. But whatever the communications are and worth, they're all turned over. So what's the need to try to get them again from Verizon?
But she said she was deleting stuff. So it's right there in writing that she was deleting things. So whatever you handed over to the defense could have been only what was left and not the deleted items. That's what they want from the extraction of Lindsay's phone, is the actual concrete data, not just a printout of texts that you think are relevant to your case because they make you look bad. So you take the ones that make you look bad out.
And certainly there's no need to get this universe of other materials that he wants to do. I understand he wants to push this conspiracy theory, but there is virtually nothing to support that. I would just say apparently for Mr. Kearney, the old adage applies. If all you have is a hammer, everything looks like a nail.
Thank you.
There's nothing to support that. It's the government's own police report.
Could this judge maybe like stop this guy's bullshit? I mean, this is irritating that that guy's allowed to say that crap when he's clearly not handing stuff over. He's clearly deflecting like they all do. And then he's like throwing out these shots at Tim Bradle in his arguments. I think the doggies need a potty break. I'll be right back. Sorry about that. We're back. And then let's just go right to it.
Report that says text messages were being deleted. And
they are.
we don't have to, especially in this day and age, what's transpired in this courthouse recently, we shouldn't have to rely on the state police for this, Your Honor. There is a report that says text messages were deleted. We're going to turn around and just rely on a printout from the implicated officer?
Right?
That's outrageous. That's ridiculous. I'm sure Verizon appreciates the government wanting to save them a little work, but tough. We need to know from a third party what's going on here. I don't want the mistakes of the Karen Reed case to be repeated here. There's nothing wrong with this court doing what's done in every civil law office in this state countless times a day. And I know we have to.
We're working in a different environment, Attorney Bradle, as you know. So the civil rules don't apply here. That the court has to apply the Lampron-Dwyer protocol in making sure that all of those criteria are met. So
I understand.
That's what I'm going to.
And we have, and we do, and it's never this clear where it's in the report that things were deleted. And so we're going to rely on the actors to say, like Howie Carr likes to say, nothing to see here, nothing to see here. Move along. Here's your papers that we printed out for you. That's ridiculous. And it is outrageous. And there is nothing, the standard for this court to order this should be about a 60-second argument. And the government always fights these things tooth and nail for whatever reason. Why they want to suppress the truth, why they want to suppress what could be out there is completely inconsistent with their duty to do justice. And I would ask that you allow it under Lampron, Your Honor. Thank you.
I don't think it's productive for me to respond to that. Your Honor, the gist of my argument, I would just make 2 points. One, I don't think Lieutenant Tully has been implicated in anything. And I take issue with that comment. And two, if you're...
Lieutenant Tully is responsible for Michael Proctor, and Lieutenant Tully may or may not have known about a relationship between Proctor and Alberts. Hold on 1 second. Dog needs a blanket. Okay, sorry about that.
I should decide to allow the motion or some portion of the motion, I would ask the court to restrict the use of whatever is developed, if the names and telephone numbers of people, particularly from the earlier conversations that Ms. Catani has been talking to, are not things that should be spread on Mr. Kearney's entertainment hours.
Thank you. I know that the record holder also has counsel present and has filed an objection to the release of those particular records. Counsel, do you wish to be heard further?
Just briefly, Your Honor.
Thank you.
We do agree with the state's argument. Ms. Catani has very serious concerns for her privacy if this data were to be released. Ms. Catani views the current Rule 17 motion as an attempt
This is Lindsay Gattani's attorney speaking for her.
to continue to victimize her even now as the indictments against this defendant are pending. She adamantly opposes any further attempt to access her private data or personal information. This is an expansive request. She believes it is a fishing expedition. She does have medical information on there. She has her children's minor children's information on there. So for those.
Why should she be afforded privacy when Turtleboy's entire privacy was stripped from him for 60 days? He was on video for 60 days straight in a jail under monitor the whole time. Think about that. What about that? What about Turtleboy's rights that she so willingly took away or had a pardon to take away?
Reasons, Your Honor, we're asking that you deny the defendant's motion.
Okay. All right. Anything else we can address this afternoon?
Bill of particulars, Your Honor.
I know that ADA Mello had filed a response.
So the government agreed to my motion, Your Honor. My motion is a particularized motion. It raises constitutional issues. And just a couple things from my motion, Judge. This type of activity, which we contend is protected journalistic First Amendment activity, has never been before criminalized or charged in the Commonwealth. So this is a unique situation, Judge. This isn't just like another case of this or another case of that. This is a unique situation. That's why I filed this motion for bill of particulars. We asked the government, with respect to the bill of particulars, that we said that we must know what prior heretofore legal and unprosecuted journalistic activity they're now perceiving as criminal. What's the activity that they're saying is criminal? They agreed to provide that. We said we need to know what aspect of the enumerated incidents allegedly comprise witness intimidation or picketing, and what evidence the government claims exists to that effect. The government agreed to provide that in a bill of particulars. Then if we look at what they've responded to on June 13th, I looked through this document, Your Honor. It goes through each of the indictments, the 16 indictments, and the 23 case. And I think it's a cut and paste job. I don't believe there's literally not one sentence in here that was an original sentence created beyond a cut and paste job from the indictments and the statute. And it repeats, it doesn't even specify the dates and times. It still sticks to the indictment verbiage of diverse case. So we still don't even know what they're talking about. So the government, to avoid an issue or whatever their reasons were, they agreed to my motion. Then they did not comply with my motion. They cut and pasted 16 indictments with plugging in the statute. So they gave me not one or two things, not a dozen things. They gave me zero information. That's their response. So I would ask that you order a proper response within 14 days.
Thank you. Hey, Cosgrove, I know you didn't draft the document, but do you want to be heard on it?
I do, Your Honor. And if Your Honor would indulge me, if you have a copy of Mr. Bradle's original motion there, could I look at it for a moment?
I have an extra one here I can give you.
Thank you very much, Mr. Bradle. I appreciate that. So initially, I may be splitting hairs. My recollection is that the court endorsed this motion as unopposed rather than assented to. That may be a small difference. And I will concede that given Attorney Mello's response, perhaps the better part would have been to oppose the motion and suggest that a bill of particulars is not necessary or appropriate in this case. And I'm not sure at this point quite what Mr. Bradle is asking for a remedy, but before I come back to that, I will say that despite the fact that Attorney Mello, on behalf of the Commonwealth, repeats that the information is readily available to the defendant in the grand jury minutes and the police reports and other discovery provided, that statement, I think, is indubitably correct. There are basically two charges in this case with multiple victims. In almost every case, the alleged victim testified personally before the grand jury and answered not only Mr. Mello's questions, but the grand jury's questions. So it wasn't a case of a police officer coming in and simply reading a police report. And if Your Honor will bear with me for a moment or two, and just pick out one victim at random, there's obviously 5 or so different sets of grand jury minutes, but I'm going to refer to the grand jury minutes of December 5th of 2023. And I am going to pick at random Matthew McCabe. And Mr. McCabe testified as to 2 incidents involving Mr. Kearney and himself and his wife. Beginning on page 42, he describes an incident where he was at a lacrosse game where his daughters were playing against a team in Bill Ricker. He was asked to describe what happened while he was there, and he replied, "Aiden Kearney showed up to my daughter's lacrosse game. My wife and I, my daughter, and other..."
And how's that illegal? He's not restricted from being there. Nothing he does here is illegal. But here he's going to complain about what Aiden Kearney, as he pronounces it, does. He won't pronounce it correctly for the life of him.
The friends were in the stands. Previous to Aiden coming in, we noted somebody videotaping us who happened to be Aiden's guy. Skipping over, Aiden came in from the top of the bleachers and approached us to engage regarding the Karen Reed case. And asked, what did he say and who was he saying it to? Originally engaged us, you know, fancy seeing you here. I forget how he started the conversation. But he was asking questions. I believe he was asking my wife questions pertaining to the Karen Reed case. And then the suburban.
How's that illegal? Nothing so far is illegal.
Which I'm skipping over. It's in evidence in the Karen Reed case, and then he might have asked if we were smarter. My wife was smarter than Karen Reed, and I believe I responded to him that his question was answered in court already, and that he should be, you know, looking at what was said in court and not engaging us. Things got a little hostile. His voices were being raised. Other people were asking him to leave. As I said,
other people and Matt McCabe were shoving him and putting their hands on him, trying to get him out of there. But Turtleboy didn't put his hands on anybody. He just came there with a camera phone, and asking questions. But somehow that's illegal.
the gentleman was there videoing it. And then as I left, I believe he was screaming, "We were cop killers," so we're murderers again. I don't know the exact words, but they were
Also not illegal.
along the lines of cop killers. I remember murderers. We are cop killers. We are murderers. And proceeded to say that as he walked out of the parking lot. Asked how that affected him emotionally. He answers that question. Then he describes another incident where Mr.
It affected him emotionally. That's how he described that incident. So they're sticking to the, I'm so emotionally harmed from Turtleboy's actions. That would just such BS. If that was a law, like everybody could go to the cops and be like, I'm so harmed by this person. Emotionally, they hurt me. Grow up, all of you McAlberts. Stop being this way. You're all crazy.
Kearney approached him when he was at Superior Court. He identifies himself as a witness in the Karen Reed case. And then he goes on to describe a so-called rolling rally where Mr. Kearney and his crowd of followers, the witness says it could have been 50, it could have been 70, I don't know the exact number. They showed up at our house. with my wife, myself, and my two older daughters. We stayed in our house. Aiden came out. I believe he had a blowhorn and stood in front of my house again. Don't know all the wording, but believe he was just there engaging and yipping about the case again. We are murderers. Murderers live in this house.
That's not illegal. You can do that. Matt McCabe could go and stand out in front of Karen Reed's house and say that. Not that I want him to, but it's not illegal to do that. You know? It's just, this is crazy. What are they charging him for? He's just reading back things that happen, but they're not even illegal. I don't understand how are we here? I mean, Twilight Zone, really.
Top killers live in this house. There were a number of different individuals there. One walked up to my Ring camera and put his face up and said, I think we're going to jail.
Even if someone did do that, which I don't think they did, not illegal.
It goes on in that vein, Your Honor, very specifically in describing these two incidents. And apart from that, Your Honor, you had the testimony of Lieutenant Tully, and he was there to introduce the video. Mr. Kearney is proud of these outrageous attempts to bully witnesses from testifying, and he features them on his show. So
Where in any of that did he bully them into testifying a certain way? And he's only ever wanted them to testify and tell the truth, which we all know they didn't do. We all know that because we watched them and they are the worst liars. Some worse than others. And they crack a lot under pressure. John McCabe, Brian Higgins, they didn't do so well on the stand. And the answers given by many of them were very questionable.
the grand jury was treated to a couple of pre-shows of Mr. Kearney's various shows portraying himself in the very act that was just described by the two witnesses. And in addition to that, the police report from Lieutenant Tully and so forth.
Because he recorded those incidents and then played them back on his show to talk about them again, that's witness intimidation? Because he gave commentary about it on his show? Again, what is illegal here? This makes no sense to me.
So if there is one thing in the world that is not necessary to have a bill of particulars for, it's this case. And I would just ask the court to strike the allowance of the bill of particulars or let it stand as is. As I say, it's a little unusual, but it's a totally fair response given the circumstances in this case. If Your Honor is going to order me to make an extended or further response bill of particulars for these 18 indictments or however many they are, they're all along the same lines. I'm happy to sit down and send the district attorney a bill for my billable hours of 6 or 8 hours of transcribing all the stuff from the grand jury minutes and the police reports and the witness testimony. But I think it would be more productive to spend my time on some of the other tasks that Your Honor has set forth for me.
Thank you. Your Honor, this is the first time this has been prosecuted. If this is so obvious what the wrongdoing is here, how come the Norfolk County CPAC unit hasn't made hundreds of arrests on this? They only arrest Mr. Kearney for this. This just happened the other day. It was all over the news on NBC when a reporter went to the Proctor's house and tried to ask questions and shouted questions at them. She was told to F off and that to get off the lawn, and she wasn't even on the lawn. You know, nobody arrested her. There's 50 people at the rolling rally. Why is only Mr. Kearney arrested? They are targeting Mr. Kearney. They're inventing crimes. That's why in this particular case, we need a bill of particulars. And let's just back up. They agreed to it. What are they asking you here? That they're trying to say, never mind? Do they want a do-over? Do they not like their deal they made? Does any commitments matter to this Commonwealth prosecution?
No.
I mean, what are they doing? The court ruled on this already. We have a ruling that's been entered on the docket, and now they want to squirm out of it. You know, enough. They need to respond, Judge. They agreed to respond. They're still not even specifying the dates. They're still sticking to diverse dates. Oh, on diverse dates, Mr. Kearney did this and that. So what about what counsel read? Okay, what part of it is a crime?
Exactly.
We've never known this before. Reporters can ask questions. That's what they do. Reporters have to be tough when they're dealing with corruption.
Reporters have to be tough, and they get vindicated sometimes, Your Honor. Look what happened to Mr. Proctor in this case. A lot of that is from Mr. Carney. And you have to be tough to ask these questions. You have to be tenacious. You have to get in people's faces. You have to ask them 50 times, so maybe the 50th time they might answer. And I think there's a few journalists in this room that might agree with me. And there's a few journalists in this room that might be concerned that this is going to be a crime. And we need to know, when the government decides to invent a new crime in an insanely broad, unconstitutional statute, they need to have their feet put to the fire as to what are they saying is the crime here. This statute is the most broad statute probably in our criminal books, Your Honor, that talks about the way to do this. People that announce their intention to go to a court proceeding are now all of a sudden have this special status. And the ways that you can violate the statute, you can invoke emotional harm, economic harm. Does that mean that if I say, I'm going to sue that person, they're lying, I'm committing witness intimidation because I'm threatening to commit economic harm on the person? The statute is crazily unconstitutional, insanely overbroad. It's going to get struck down. And the government here is trying to use it. Let's be real here. The government is trying to use it to shut down Mr. Carney, who was making all sorts of headway against the state police, the district attorney's office, the Karen Reed investigation, and they're trying to shut him down. That's what this is all about. They took this statute that's never been used this way before, and they just apply it to him. So that's why we need a bill of particulars, Your Honor. That's why I filed a 3 or 4 page thing alleging constitutional issues. They agreed to it, and then they completely blew off compliance. And that's the posture here. They're asking you for a do-over. I don't know what's going on here, but we need to know those things because it's a brand new, it's a brave new world.
Let me ask you this. Does this affect your ability to file the motions to dismiss that you indicated you were going to file on the last day?
It does, Your Honor, because I need to know what they're saying is the crime and what they're saying is okay. You know, we're at the point where we need to go to the government to know what's okay now under the First Amendment in Norfolk County. Can we use a bullhorn? Can we bring 5 people out to protest? Can just one person protest? Do you need to be a certified journalist with a fedora and a press card? Or can you be a regular person and still have the benefit of the First Amendment? We don't know that in D.A. Morrissey's county. We don't know that. And that's why I need a bill of particulars. What are they saying is the wrongful behavior here, Your Honor? We don't know. I think that maybe these journalists might like to know too. Some of these journalists are pretty brave when they get in people's faces who they think are corrupt, killers, criminals, people who have newsworthy information. That's what this country's all about, Your Honor. And they are trying to shut it down. And they should, the court's the only bulwark we have. And they should be held to account to make us aware of what they're saying is the crime here. Given the breadth of the incredible breadth of the statute, and given it's shocking when you read everything, it's behavior that you see teased on commercials at night when you're going to watch the news at 11 o'clock at night. You see something like, you know, Ted Daniel on the news at 11 tonight. He went to so-and-so's house and got the story. You know, Ted Daniels doesn't get arrested, and anybody else doesn't get arrested. Anybody sitting in the gallery doesn't get arrested. Mr. Carney gets arrested. He gets shut down. They steal all of his stuff. 9 months later, they don't give him his stuff back. They still want to stall and say, oh, we can't give him his stuff back.
We're not going to rehash all the prior arguments.
You get it.
I'll review the bill of particulars. If there's anything that needs to be supplemented, I will advise both sides.
Thank you. Could I just say 3 words, 3 sentences in response to him? I hear Mr. Bradel say that the statute is unconstitutionally broad. I hear him say that the Commonwealth is engaging in selective prosecution. And I hear Your Honor asking him, need a bill of particulars to file a motion. I'm not quite sure the motion's involved, but certainly you don't need a bill of particulars to ask for a ruling to the court as whether a statute is unconstitutional. And you don't need a ruling on the bill of particulars to make a claim of selective prosecution. And you also don't need a ruling on the bill of particulars, and I don't know if this is what Your Honor had in mind, because the last time we were before Your Honor, Mr. Bradel indicated that he wanted to file a McCarthy or an Odell motion, but he couldn't do that because he didn't have the discovery. He's got all the grand jury minutes now, with the possible exception of one that I thought he was provided, and I said I'll get him tomorrow. Bill of particulars doesn't enter into a McCarthy or an Odell motion. It's strictly limited to the evidence that was presented to the grand jury. So I would just ask the court to take with a grain of salt all of these claims that Mr. Bradel has all these wonderful motions that he could file. If only the Commonwealth would jump through yet another 6 hoops for.
Thank you. All right. So Commonwealth.
What an ass. I'm sorry, but he is. That Cosgrove guy.
August 1st, you'll advise the court whether you'll be able to provide a copy of the phone extractions, the computer extractions, or whether that will need to be further addressed. Also, the motion for the
phone extractions you're on, I'm sorry. The phone extractions you're on, and you mean the jail call?
No, the 3 search warrants that you had referenced earlier. That information, that by August 8th, motion regarding the taint team should be filed on or before that particular date. And we'll put it over for the hearing parties available on August 22nd, 2 p.m.
That's not fine, Your Honor. Is that Thursday?
I believe it's Thursday.
Yeah.
Yeah, that's a good date, I think, for both of us.
Okay. Attorney Bradel, is that a good day for you and your client?
Judge, I'm sorry, it's not, 28th available? August 28th?
That's a Wednesday.
So once you want to keep it on the Thursday.
Is 21st? Oh, I'm sorry, no, my client is not available, Judge. 29th, sure.
And that will be at 2 p.m. Okay. Mr. Carney, your matters are continued to August 29th at 2 p.m. Thank you.
All right, so August 29th, 2 p.m. is the next hearing for Turtleboy. Let's switch over here. I want to show you guys his after hearing, like his post-hearing press conference. So this is him and Attorney Bradel discussing what just happened inside there.
I don't know.
And the audio is not great on this, so I apologize. Where are they? They weren't coming down the stairs yet. I had it back too far. Sorry. Oh, here he is.
Just mad because they couldn't find Karen Reed guilty because Karen Reed is innocent. Now they're trying to put it on you. Okay, that's right. So. Any friends? Good. How are you? How'd it go today? I thought it went pretty well. Tim did great at the end there. Excellent job. Really passionate defense of the First Amendment. Did everything we wanted to say. Yeah, and that special prosecutor, he's really special. Yeah. Well, you know, like you said, took about an hour and a half in there. We're just trying to get the information in the bill of particulars about how the First Amendment has suddenly become a crime, why I'm the only one who apparently is guilty of committing a crime. They haven't explained any of that. And you know, they're prosecuting me. They arrested me. They took my devices. They've had them for 9 months. They could easily just make a copy of the phones and give them back. But, you know, they took my computer, the tools of my trade. And there's really no reason for them to have them anymore when they can easily just make a copy. So what's next? Where do we go from here? Well, the wheels are moving slow, but you know, that's the system. The corruption. It'll happen. We're going to persevere. We're going to overcome. We're going to persevere. So we're going to get there. All right, we're dealing with the finest corruption.
So what were you saying about the evidence they have? It's not from the phone itself? Is it just screenshots?
We have printouts, right? And we want to have some assurances of reliability.
Anyone can delete text messages.
Yeah, and destroy phones.
And you saw in his own report that they're deleting messages. So what else have they deleted? We can't, with the Colin Albert text too, we can't trust a screenshot. We need the full data extraction report. Pretty standard. And I don't know why they're hesitating if they have nothing to hide.
Exactly.
I don't know. I don't want to say, I don't have it in front of me, but we believe there are, you know, we believe what the police wrote in the report, that things were deleted. So we want to explore it. We're entitled to explore it. Simple.
I can't hear the
No, I don't think they're saying that they gave us the deleted items. I think they're saying they gave us what they have, which I take them at face value, but they might not have things that were deleted. So we need to go to the source. We need to go to Verizon. I don't want that. I don't want that business to happen again.
He claimed that on the printout is the message where she tells them to delete everything, and that is on the printout. But if they're going to delete that, what else have they deleted? What else are they hiding? Why not just give us the full data extraction report? Well, that's what I'm wondering. We don't know. We don't know. We won't know.
I'm told that we have some indications that there are things that are not
there that are supposed to be there. When we got the extraction report of her phone, there were no messages from Tully on it. They're gone. So what else is gone? What else was not given to us?
What about the ones Tully sent? Was there messages on there that wasn't in the evidence that was shown to you?
No, we don't want to speculate, that's why we want to go to Verizon. Let's just get the record. And
Okay.
let's see what we can get. That's all there is to it. There's no funny business. Just let's go to Verizon, let's go to the source, let's get the records, and let's see what there is. When's the next date? August 29th, right? 29th. August 29th. So.
Found on the value of the bill of particulars.
Yeah, so they state conduct that you journalists engage in all the time, where you confront people, you chase down people, you go to their house, you go to theirs, you go here, you go there.
Yep.
They're alleging that that's a crime without explaining it. How did that suddenly become a crime? And why is it only a crime as applied to Mr. Carney? Not that we want anybody else to get arrested, but we certainly don't want him to get arrested.
I was glad that if I said anything to Lowry, that I'll be arrested for intimidating a witness.
The charging documents are basically a recitation of comments I've made on my YouTube show, followed by a copy and paste of statute. But at no point do they connect the dots and say how this speech I'm using somehow violates this, because it doesn't. They can't connect the dots, and that's why they're not giving it to us. That's why they're fighting. But they agreed to it, so I don't know why they want to do over now. Thank you, guys. Good job in there, bud. The fight continues.
Cases when items have been seized from your clients, how quickly are they returned? What is the behavior? How unusual is this?
I've had cases where the items are returned because the investigators take what's called a mirror image of the device, and then they go off of that, investigate off of that. So there's no real need for holding on to the person's devices, other than this sort of minimally probative idea that, oh, well, we need to show the chain of custody. We need to show they're really his electronics. And here I offered to stipulate that they're his electronics. So there's really no reason for them to, but they're still refusing to agree. So
It was 9 months ago today.
9 months today.
In terms of the First Amendment argument you made, I'm curious as to what you made of Judge Rupp's ruling prior. When he made the ruling, it was basically he had some comments where he basically didn't quite buy that everything that Aiden was doing was journalism, was conventional journalism.
Yep.
All right, so
You're welcome. What's your response to that? Obviously, you brought up going to people's homes, but I think that's maybe a different situation that I'm assuming the Commonwealth will argue on. Potentially, I don't know.
Well, the government has to give citizens fair notice of what's a crime. And they haven't given anyone fair notice of what's a crime now. What journalism is a crime and what isn't? Why can't you call someone and leave a message? I mean, that's what journalists do. Hello, can you give me some comment? Call me back, right? But, a tenacious journalist has to call 20 times to get the person. Has to go to.
it's like they're just making up the rules as they go. And they don't like our Aiden exposing them for their corruption. And that's all they're doing is using this statute as a weapon to intimidate them or to silence them. Sorry.
For the sports event, has to go to the house, has to wait for the person to come home from work. And now that's some of that. Some are part of that apparently is a crime in DA Morrissey County, Norfolk County. So we'd like to know exactly what it is.
But I mean, beyond that, the judge, I think he made a delineation. He said, hey, there's some choice words being used on these voicemails and the numbers are being posted and people, got calls after that. I mean, and I'm not sure that that's always the way. Like, I don't always see that on Ted Daniels.
Where do you draw the line? Are we a government of laws or men who decide the line arbitrarily and based on who's in front of them, whether they like the person or not? We contend that's what's going on here. They're drawing the line against Mr. Carney. They might not draw the line against some other reporter who shows up at someone else's house. That's, depends on who talks. Get range. I don't want to specifically say I don't have it. Really, I don't have it. I mean, I want to be as precise as possible, but I think you guys get my position.
And in terms of, I know, but getting frustrated a couple of times. it looked like at least when your brother was speaking, I'm wondering if you have a sense for why he was appointed here. Obviously, he's a former judge himself. Just any comment you have on him.
No comment at all. We go back and forth. Lawyers make their comments and go back and forth, and sometimes it gets a little heated, and that's okay because there's incredibly important issues at stake here. And lawyers can disagree without being disagreeable, and that's how it'll be the case. And,
I like that. Disagree without being disagreeable. That's what lawyers are supposed to do. I'm sorry for the sound. I'm sure it was windy that day or something because it's hard to hear.
Need to be
Just a little bit more.
That's Brad. Brad's in the court every day.
Okay.
Okay, here, he's causing trouble.
All right, you can't hear anything now because multiple people are having conversations. I thought it was interesting to hear Tim Bradle's answers to the journalists that were there, the other journalists that were there. So that's it for our clips, but we have some things to read through. So stick around with me. I've got a bunch of different things to talk about still. All right, so the next topic is after court. So after court that afternoon, the Justice of Superior Court, Michael Cahillane, however you say it, came out with some orders. So here is a court order for Rule 17 summons. Oh shoot, you guys are not seeing what I'm seeing. All right, there we go, better. All right. So it is hereby ordered that Cellco Partnership DBA Verizon Wireless provide the following records within 30 days to the clerk magistrate of this court upon service of a subpoena issued pursuant to Mass RP 17. Any and all call detail records for telephone number redacted starting at 12 midnight Eastern on December 3rd, 2023 through including December 24th at midnight. So I get those 2 full days of text messages and voicemail and whatever she might have been doing on her phone looking to set up Aiden, perhaps. Upon production, any record shall be inspected only by defense counsel of record. Defense counsel is prohibited from copying any record or disclosing or disseminating the contents of any record to any person, including the defendant, which I think is BS, but still, at least Tim Bradle is getting it, subject to further order of this court. So he really wants to make sure that things don't get put on the internet, which I do think is BS because it's your case, your court case, and if you have a platform to share it, I think that's BS that they're not allowing that. All right, then next, this is the decision and order of defendants' oral motions for Commonwealth to supplement their bill of particulars. So the judge was listening to Tim Bradle. He was listening. On February 23rd, 2024, the defendant filed his motion for bill of particulars. At a hearing held on April 23rd, the Commonwealth, through its Special Assistant District Attorney Kenneth S. Mello, did not object to complying with the defendant's motion. On May 23rd, 2024, the Commonwealth was ordered to comply with the motion by June 13th. On the due date, the Commonwealth filed its bill of particulars. The defendant now claims that Commonwealth's response is insufficient. Quote, a bill of particulars should give a defendant reasonable notice of the nature and character of the crimes charged. However, a bill of particulars need not describe in detail every item of evidence that the Commonwealth intends to introduce, and while the bill of particulars restricts the case which the Commonwealth is entitled to prove, a defendant in a criminal proceeding is not entitled by a motion for a bill of particulars to secure a resume of the evidence that the Commonwealth intends to introduce at trial or to have such motion treated in all respects as if it were a set of interrogatories. That's quoting from Commonwealth versus Hayes. As such, judges should not order particulars which, in their requirement for detail or otherwise, amount to the imposition on a straitjacket of the prosecution. Commonwealth versus Binney. Nonetheless, the Commonwealth's Bill of Particulars falls short in advising the defendant and the court of the time and place, manner, and means of the defendant's conduct for each of the alleged incidents that constitutes violations under that statute. Therefore, the Commonwealth is ordered to supplement its Bill of Particulars no later than Friday, August 1st, 2024. So there you have it. Two really big wins for Aiden in court last week. So he had the records of Lindsay Gattani for 2 days. He's going to get those records to find out who she was talking to, what they were saying, conversations that were being had, maybe colluding together to conspire to get him arrested. Collusion and conspiracy, maybe. All right. And then he wins a more detailed bill of particulars, asking for the time and place, manner, and means of the defendant's conduct in which it violates that statute. So hopefully they get something better, or it gets dropped, but I doubt it. That would be great. That would be the best thing, is if his charges get dropped. Now, the last thing I want to go over with you guys, so much has been going on, and the trial's over. All right, so this is we're going to call it a McAlbert PR campaign. So this first email, oh wait, hold on, I'm missing one second. All right, this is the one I wanted to read first. So this one's an email from Courtney Proctor to some the governor and Colonel Mon, the head of the Massachusetts State Police, Governor Healy. This is an email campaign that Courtney Proctor, Michael Proctor's sister, is trying to get out there to like top people in these law enforcement organizations and government. All right, so hi everyone. As you know or have heard in the news, my brother is under an internal affairs investigation with the Mass State Police over the misuse of his personal text messages. That's not exactly why he's under internal investigation. There's a lot of things that he did, like planting taillight and lying about his close relationship with the McAlberts, and even setting foot there because he shouldn't have, because of his close relationship to the McAlberts. But anyways, these just show like how low these people will go. It's disgusting. Police over the misuse. Oh, wait, sorry, hold on. Over the misuse of his text messages. We have learned that the state police is potentially going to impose the most severe type of punishment, which is termination, which is well deserved. He deserves to be fired and to never work in law enforcement ever again. Michael has had a 10-plus career, shouldn't say years, 10-plus career with the state police that has consisted of promotions, accolades, and not one violation or complaint against him. Until now, he has been used in a political chess game that has nothing to do with the Karen Reed investigation he and his office led with fidelity. BS. They did not lead with fidelity. They definitely lied, planted evidence, tried to frame an innocent woman, lied about their relationships, all sorts of things, hid evidence, destroyed phones. These people are not good people. So I don't know where they're getting, he led that investigation with fidelity, but okay. I am trying to help push an email campaign to the governor and the colonel of the state police ahead of Michael's IA interview next week, where we learn of his final punishment. I think this must be sometime this week. He has a final internal investigations interview, like he did, or hearing. Why do they call it an interview? Shouldn't it be a hearing? Anyways, please help by mailing Governor Healy and Colonel Maughan. Neither one of them are going to fall on the sword for Michael Proctor, by the way. So this is not going to go anywhere. But that's coming from Courtney Proctor. Now we also have another email campaign to elected officials. They've got like Joshua Levy on here, bunch of troopers from Massachusetts State Police, Maura Healy, that's the governor. I don't know who all these people are. John Maughan, Colonel Maughan, who is in charge of the state police. These are all people that the McAlberts want. They're trying to get an army of people to do this email campaign with them. So, friends, there's an email campaign going around directed at our MA elected officials. Goal is to inundate inboxes in an effort to prevent Governor Healy from firing all the investigators in the case against Karen Reed. And when they should be fired. And to call out the unfair federal government investigation. What? The federal government investigation is not unfair. How is it unfair? And the political bias going on. It's become more political than ever, and we don't need a message of disapproval now than justice for John O'Keefe will be at risk if we don't send a message of disapproval now. Sorry. The email should be sent out no later than Sunday. If you get a response to your email to fill out a form, then please fill out the form. Please feel free to share with other, quote, good people out there. And then here are the people they should email. Use this email template or alter as you wish. Sorry. It's hard to read this, first of all, because it's blurry for me. And then secondly, it cut off. All right. I hope this message finds you well. I am writing to bring to your immediate attention a matter of serious concern regarding a criminal murder case, Commonwealth versus Karen Reed, that appears to be compromised by witness intimidation, frivolous investigations, and potential political interference. The only political interference now is you guys doing this email campaign. Anyways, recent statements and actions indicate that government agencies and elected officials may be conducting investigations for political motivations rather than impartially pursuing justice. The integrity of our legal system depends on protecting the civil rights of law enforcement officers and witnesses. As a citizen of Canton and a friend of the Albert, McCabe, and O'Keefe families, I am appalled at the lack of intervention on behalf of the victim's family, law enforcement officers, and witnesses over the past year and a half. The level of harassment, intimidation, and slander suffered by these individuals is horrific. You know what? The only people that are harassing, intimidating, and slandering is that side. It just baffles me how freaking ballsy they are to be the bullies and then to turn around and say, we're being bullied. Rather than protecting the victim's family, witnesses, and law enforcement officers, the Norfolk Superior Court, all Attorney General's Office, U.S. Attorney, and Governor Healy have allowed and chosen to conduct frivolous investigations that include violating Michael Proctor's civil rights and allowing communications from his personal cell phone, as if that matters. Personal or work, what difference does it make? He shouldn't have been saying any of the things he was saying, personal or not. But they like to make this thing like it. Well, they're violating his rights because they went into his personal cell phone. Why does he have immunity from his personal cell phone when us regular folk wouldn't? That makes no sense. Anyways, historically, there has been far more severe incidents of police misconduct that have gone unpunished. The termination of an otherwise upstanding law, something, it gets cut off. I don't know. Furthermore, Norfolk Superior Court failed to adequately protect court proceedings from outside influence and allowed a blogger charged with the intimidation of witnesses inside the courtroom during proceedings. And what did he do? Did he intimidate anyone while he was in the courtroom? No. He sat there and he reported like a reporter would. So I don't know what this person is all up in arms about. His presence, along with the protesters who were allowed to create a disruptive and disrespectful environment outside the courtroom, directly influenced the jury and contributed to the outcome or lack thereof. No, it didn't. No, it didn't. The jurors were bussed in and brought in the back door. They didn't see they didn't see the extent of the protesters, not like we did, and if they saw them at all. And then, what else was I going to say? Oh, the protesters are people that are standing in support of Karen, and they're very peaceful. And if you would pay attention at all to social media, you would see, if you like looked in on yourself, watch the streams. They're nice people coming together for a cause. Efforts should be focused on upholding and protecting the judicial process, but instead, your focus is to launch a public relations campaign for political benefit targeting upstanding state troopers. They're not doing anything. They had no other choice. Based on Michael Proctor's conduct and his alone, they have no other choice but to terminate him. They have to. This is a clear misuse of authority. How so? Or a deviation from legal standards based on political motivations and potential personal connections. This questions the intentions and motivations of the offices of the Attorney General, U.S. General, and Governor Healy. The wrongful termination of Michael Proctor and the senseless investigation of John Fanning and Yuri Buchanan directly compromised the retrial of Commonwealth versus Karen Reed, undermining the district attorney's case and tainting the potential jury pool. Not only do these actions directly interfere with Commonwealth versus Karen Reed, but also Commonwealth versus Aidan Carney and any future civil suits, I ask that you postpone any actions or investigations of law enforcement officers until after these trials to retain the integrity of the legal process. The O'Keefe family, witnesses, and law enforcement deserve better. Given the gravity of these concerns, I respectfully urge your office to initiate a comprehensive and impartial investigation into these concerns. It is essential to ascertain whether. So you just basically told them they were being shady, corrupt, whatever have you, and now you want their help. You just ripped apart Governor Healy, U.S. Attorney General, and the Attorney General. You just ripped them apart, and now you're saying, we need your help. It is essential to ascertain whether any court proceedings or government activities have been influenced or driven by political considerations rather than legitimate objectives. Additionally, measures must be taken to safeguard the integrity of the Commonwealth versus Karen Reed, blah, 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 and political agencies. Isn't that crazy? And then this one, yeah, this is another one. All right. Shrink that slightly. Dear Governor Healy, I am writing to express my concerns regarding the ongoing internal investigation within the Massachusetts State Police with specific reference to the Karen Reed trial and the suspension of Trooper Michael Proctor following the revelation of his derogatory text messages concerning Ms. Reed. That's not why he's under investigation. But keep telling yourselves that. A significant portion of the public has labeled Trooper Proctor as corrupt and biased. I wonder why. However, it is essential to recognize that, like every U.S. citizen, he is entitled to freedom of speech under the First Amendment. Where was Aiden's freedom of speech when you guys had him locked up for 60 days? Where was that freedom of speech? Where's his freedom of speech now with his felony witness intimidation charges? but you want to say that Trooper Proctor is exempt from being fired because of the First Amendment. No, it doesn't work that way. The First Amendment means you can say whatever you want. That doesn't mean consequences don't happen sometimes when you say things that are probably not appropriate in the workplace, especially, even if it's on your personal phone. Anyways, this fundamental right, which is equally exercised by protesters outside the courthouse, should not be grounds for vague and unreasonable suspension. Every citizen has the right to be critical and to express their opinions. There is no concrete evidence to suggest that Trooper Proctor maliciously planted evidence. There is plenty of circumstantial evidence that suggests it. It not only suggests it, it makes it the only logical reason as to how Taillight got on the scene is that somebody brought it there because her taillight was not cracked when she dropped John off that night. She cracked it 5 in the morning, 6 in the morning when she went out driving to look for him. And we know this. So obviously somebody planted taillight. Nevertheless, while his text messages are contrary to the ethical standards expected of law enforcement officers, they remain protected under the First Amendment. So you admit that they're not under the ethical standards of the law of what law enforcement should live by. So right there, maybe you shouldn't be a cop. These communications, although unprofessional, do not constitute a valid reason for his suspension. Actually, I would claim that they do. Manner in which these messages were introduced into trial raises questions about the integrity of the judicial process. What? Adam Lally brought them in. The state brought them in. Michael Proctor sat there and read them on the stand for hours. He brought them in. The state brought them in. I don't understand. What is she talking about that the way that they came in was not, there was no integrity? It appears that the introduction of these texts may have been politically motivated, especially in an election year. Also, they're saying somebody sacrificed Michael Proctor as the sacrificial lamb. The case has caused considerable public outroar, with allegations of corruption that merit thorough investigation. It is crucial to examine not only Trooper Proctor's actions, but also the broader context in which these communications were utilized against him. Advocates for freedom of speech, such as bloggers like Aidan Carney, should recognize that this right also protects Trooper Proctor's communications, respective of their content. Oh, we get that, but it doesn't make it exempt from him losing his job. I urge you to investigate the underlying issues of corruption and ensure that justice is administered fairly. Both law enforcement officials and their critics should be held to the same standards of fairness and freedom of speech. Thank you for your attention in this matter. I'm not sure who was sending that, but somebody, it's just another email to Governor Healy. I mean, they are on a campaign. This is somebody said from Jen. This is a quote. We are trying to rally from Jen McCabe. We are trying to rally a group to go to court date in July 2020. Wait, what? This is bad writing. We are trying to rally a group to go to court date in July 22nd. It seems like a decent amount are going, but the more the better. Just need people to wear blue, can buy a t-shirt for $15. They don't have to do anything, just be there in support. Court is at 9. Would be great for the O'Keefes and witnesses to see people support them. There'll be Justice for John t-shirts, and they are purchasing lawn signs that will be available next weekend. So they're trying to counter protest the Karen Reed supporters. Just because you support Karen Reed doesn't mean that you don't support the O'Keefes. which I find to be insane that people don't recognize that. You can support both. I want the O'Keefes to get justice, even if I don't like them. I don't really like um, Paul O'Keefe or the mother very much. This is very blurry, and I apologize. It's very hard to read. All right, so this is another email campaign that just went out, and they had it signed by like all these people. Jim Ferris is on there twice. Some people might be on there twice. And they're all Alberts or McCabe's or whatever. They're all, friends of those people, friendlies. They're friendly with the McCabe's. All right, so Rita Lombardi does not speak for us. Rita Lombardi is an outspoken Canton resident who attends the rallies for Karen. She attends the Canton Select Board meetings. She's awesome, and she says some really insightful things and helps try to get people to come together. For whatever reason, these people have it out for Rita. She's been harassed by these people, so it just goes to show they don't like people who are strong, independent, and have a voice of their own. Independence Day reminds us of how a group of brave individuals stood up to bullies. Yes, they stood against an intrusive, overbearing, and aggressively bullying monarchy. Thankfully, today, we do not face such a government here in the United States, the Commonwealth of Massachusetts, and especially not in the town of Canton. Really? Because I think that your government is a bullying monarchy, for sure. Commonwealth of Massachusetts, Bev especially. Nearly 250 years ago, those brave individuals declared their independence from the monarchy and stood against bullying as a unified voice. Sadly, with the recent events in Canton, many of us have felt we've lost our voice to the insane rantings of a small group of very vocal people that claim to want reform, but to get what they want, they employ the same bully tactics used up by their blogger leader. They really hate Aiden. Name calling, making false allegations, whatever. It's hard to read, guys. Spreading malicious rumors and innuendo. Control the narrative. Silence the opposition. Scare them into silence. This is so blurry. They have recruited people from within the town of Canton, as well as people from other municipalities, to flood our events and meetings with the noise that they use to drown out the possible dissenting voices. No, they don't. You guys are just mad because they outnumber you. And they're coming on their own free will, and you guys have to rally people. They have shamelessly turned the tragic event of the loss of John O'Keefe's life, a son, a brother, an uncle, a neighbor, a friend, a citizen of Canton, and by all accounts a wonderful person, into a carnival, not an officer, how about an officer of the law, a brother in blue, and they've turned it into a carnival complete with tailgating, pom-poms, signs, and t-shirts. Well, aren't you guys trying to do the same right now? So how are you going to judge them for that and then you're going to do the same? Selling popcorn, advertising, and making a homicide trial a spectator sport, all while continuing the abusive tactics of name calling and false accusations. Simply disgusting. Makes me want to barf the way that it's written. With the memory and inspiration of our nation's founders, it is time for the rest of us to stand up to the bullies and declare our independence from the mad crowd. We, the sound-minded people of Canton, yeah, right, the sound-minded people of Canton. Jill Daniels is on here somewhere. Jill Daniels is the one that came Jillian Daniels, she's right here at the top. She's the one. These are the sound-minded people, mind you. She's the one that came up and assaulted Aiden the weekend before the trial ended. And so did Jim Ferris. Jim Ferris came up and assaulted Turtleboy too. But these are the sound-minded people of Canton that have signed this. So obviously this is very reassuring. because Jillian Daniels and Jim Ferris, the people who just lash out and assault random people in the street. We, the sound-minded people of Canton, declare our independence from the sad group of bullies and reject in every way their tactics, false allegations, misdirected anger, and hatred. We support our town officials, our select board. We kiss ass, guys, even the ones with whom we disagree. We support and respect our first responders and brave men and women of the fire and EMT services and their leader, Chief Robbery. We support and respect our brave and honest police officers and their leader, Chief Rafferty. Yeah, she's honest, and she lied about a hit and run. Or, well, it wasn't a hit and run. She hit somebody, a pedestrian, with her car, and she didn't tell anybody about it for months. We support our town workers in all of our town offices and in all their capacities because we kiss ass all the time. We resolve to be heard as one voice for Canton, to stand up to abuse and hatred, and to stand together for justice to reclaim our town. Rita Lombardi does not speak for us. Respectfully signed, the lunatics of the town. And here are all of their names. Yeah, effing crazy Fs. I really want to swear, but I don't want to get stricken. Yeah, that's the other side. That's what the other side looks like. The unhinged, crazy folk that want to start this PR campaign to kiss their asses, kiss the governor and attorney general's asses after they insult them. Does this make any sense to you guys? I don't understand. But that is what a bully, I guess, would do. So let me know what you guys think. Wow, I didn't expect this to go for 2 hours. There's just so much still to talk about in this case that it's crazy we're still here talking, and I'll probably have another video again soon. Please hit the like button on your way out. Thank you guys so much for watching. I really appreciate it. Let me know in the comments what you think about this case. Will it ever end? Will justice prevail for Aiden, Turtleboy, Carney? Will it prevail for Karen Reed? Let me know in the comments below. And I thank you guys again for watching. Take care. Bye now. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.